Well, the debate over the constitutionality of Central Bank Governor Godwin Emefiele's presidential interest or political ambition is raging on. Opinions are split, and the perspectives abound. The dictates of the law are clear or unclear, and the gray areas need some light. Who is a political appointee? Who is a public servant? Who is the, choice of the people? But where's the thin line in all of this argument? How does the law exempt public officials from politics? What are the loopholes or justifications, if any, in these laws? Well, it's our conversation tonight on VSA. I'm Sulaiman. While citizens, civil society groups, and legal minds have weighed in with their points on public servants' aspirations for political office, but the 1999 Constitution, the Code of Conduct of Public Officials, Public Service Rules, the Electoral Act, and the CBN Act are the latest companies of Nigerians in these debates. Now, on Monday, the Central Bank of Nigeria governor filed a lawsuit at the Federal High Court in Nigeria's capital, Abuja, asking to order INEC, that's Nigeria's Independent Electoral Commission, to allow him to vie for office without resigning. That's, you heard right. Now, this was restrained by the court, which is set Thursday for the Attorney General of the Federation and the electoral umpire, INEC, to explain to the court why Governor Emefiele should not be allowed to vie for office. Now, opposing voices have said the presence of the CBN Governor is potentially harmful to the autonomy of the Apex Bank and the integrity of his office. Now, Section 9 of the CBN Act of 2007 states that, quote, the governor and the deputy governors shall devote the whole of their time to the service of the bank, and while holding office shall not engage in any full or part-time employment or vocation, whether remunerated or not, except such personal or charitable causes as may be determined by the board and which do not conflict with or detract from their full-time duties. End of quote. Now, there's more to come, and we have with me tonight Dr. Tunji Ogunyemi. He is a senior lecturer in economic history of ObafemiA Awolowo University in Ile-Ife, Nigeria Southwest region, and Chime Kingsley, who is a legal practitioner. Now, good to see you both, and thank you for your time, Dr. Ogunyemi. Quickly here, I'd like to get your reaction when that news first hit you, because Nigerians are divided on this, and it's still a very big talking point by, in circles in Nigeria. How did you receive the news first, saying Governor Emefiele, asking, to vie for the presidency of Nigeria?
Well, just as anything Nigerian, I was not shocked. I think some of us have grown such a thick skin to unusual things in the polity that we no longer get surprised by unusual behaviors. But if you check very closely the relevant laws and the regulations applicable in Nigeria. Number one, the public service rules. Number two, the CBN Act, particularly Section 9, as you have rightly mentioned. And then you check also the third and the fifth schedule to the Constitution of the Federal Republic of Nigeria 1999 as altered, particularly the first item in the fifth schedule of that relevant provisions of the Constitution. You will see that there is clearly an issue referred to as conflict of interest. Conflict of interest. And what amounts to conflict of interest can only be defined or can only be ruled upon by the Code of Conduct Bureau. And in several instances, several cases, that we cannot, we need not waste time on citing those instances. But on several instances, the CBN, the Code of Conduct Bureau, has ruled without any iota of doubt that an officer in very sensitive offices of the Federation, such as those who head the military service, those who head the police service, those who are in the central banking system, those who are in charge of the security apparatuses of the country are stopped from participating in whatever form in partisan politics, howsoever described. In fact, the CBN Act, as amended, is intended directly to shield the CBN and the operators of the CBN from any form of political interference. Now, the question now is the participation of a CBN governor capable of being interpreted as participating in partisan politics? The answer is yes. The answer is absolutely yes. And at any rate, is he a political appointee? Within the conception of Section 318 of the Constitution of the Federal Republic of Nigeria, 1999, as altered, the CBN governor is a public servant. The term political appointee is only a function of a recent law, that is the recently amended Electoral Act, particularly Section 84 of Section 12, which defines such officers as political appointees. But the truth of the matter is that the constitutional provision in Section 318 clearly defines clearly brings the CBN governor within the purview of a public officer. And as a public servant, he can participate in politics, but not in partisan politics.
Let's take that again, Dr. Ogunyemi. He can participate in politics, but not in partisan politics. Just expatiate, for us here.
Or for example, take for example, any Nigerian can be a member of a political party, and he can vote and be voted for. But once he begins to act as a party apparatchik, that is contesting for party positions, such as governors, such as House of Representatives, House of Senate, and etc., then is into partisanship. And the CBN Act clearly intends to exclude such officers in sensitive positions from partisanship. You see? So that is the difference. It's not that if he cannot be a member or he cannot vote and be voted for, but he cannot do partisan politics. It's like a general in the Nigerian army also beginning to say, because nothing stops a general in the Nigerian army also saying he wants also to participate and be elected an officer.
Let me jump in here and quickly welcome Chime Kingsley, and I hope the connection will stay. I try to welcome you proper to the square, and it suddenly disappears. Welcome to the square, Kingsley, and we're looking at some of these happenings in our space, as you know, and Dr. Ogunyemi has been able to draw a line between a public officer, political appointee, and also talk about, being a member of a political party and also playing what they call partisan politics. Help us here, Kingsley. Let us first get a sense of how the news got to you when you heard that Godwin Emefiele, Nigeria's central bank chief, would like to run for the office of President of Nigeria.
Well, thank you so much for having me, and good evening, viewers. Unfortunately, I didn't get your question correctly. I want to assume that you are asking questions in connection with the indication that the central bank governor intends to run for the office of president. Is that the question?
That's it. That's fine.
Well, it's really unfortunate. Let me begin by saying that it's unthinkable that a time would come in Nigeria where the central bank will be exposed to the level it has been exposed in recent times, that the central bank of Nigerian governor would contemplate, joining the murky waters of politics, particularly in Nigeria. And I also understand that he also took it a bit further by institutional action in the court for interpretation of certain provisions of the law. It is appalling and it's unfortunate. When I got the news, I assumed it was not going to be real. But as events unfold, it seems to me that there is more to it than meets the eye. Ordinarily, one would think that the Constitution has made it very clear, particularly the provisions of the Electoral Act, of 2020, which excludes political appointees from vying for political office, except you resign within a specific period of.
Well, I think we're having that glitch again there, Chime Kingsley. I think there's a glitch in the connection, Chime Kingsley. We hope we can rectify that so that you can jump back into the square. But quickly here, apologies, Kingsley, but we need you, being a legal practitioner, to help us also make sense of some of the legality or otherwise of what we're having tonight. I go back to Dr. Ogunyemi, and some of the key things you've been able to unwrap here will make people ask the question if this interest of the CBN governor would have any impact on Nigeria's economy.
Oh, of course, absolutely. I mean, for example, how will the CBN governor, for example, who seeks to get the nomination of a political party, in other words, he who seeks to go to the field to canvass for votes from partisan persons, how will he be able, for example, to deal with the banks directly owned by such persons? How will he be able to effectively regulate them? How will he be able to regulate them such that partiality will not come into play and its neutrality will be upheld, especially within the light of Section 9 of the Constitution of the Federal Republic of the CBN Act, sorry. So the CBN Act intentionally was made by the legislature to immunize the CBN and the officers running the CBN for political interference, one, partisanship, two, and all manners of political intervention that will have serious economic implications for the economy. For example, the CBN governor participating in politics will actually mean that it can no longer be trusted to be an impartial umpire to regulate the financial, if you like, the monetary policies of the country. And in terms of the monetary policies of the country, you also have issues that has to do with the regulation of the banking sector. The Banks and Other Financial Institutions Act is clear on the issue of partisanship. I mean, the CBN governor can even on grounds, I know that morality is not the same thing as law, on grounds of morality. I mean, you do not go to descend into the arena and then expect that the market will not receive a terrible shock. I mean, were Nigeria to be a highly capitalized economy, you would have seen the reverberative effect manifesting in the stock exchange, in the value of the naira, in all manners of financial institutions and negotiable instruments, because people will now say, oh, the CBN governor is now voting for a political party, and that political party may or may not win an election, and then speculations begin in respect of the value of the naira. I think common sense should just prevail here. Common sense should just prevail here.
And while we await common sense in all of this, you've also given us, an idea of or the intendment of the lawmakers to put in that provision to immunize the CBN from such interference. But now that this is happening, let's go back to Section 11 of the CBN Act that calls for the prosecution of anyone who fails to abide by the rules. In Section 9, which you have also, highlighted. Now, in this case, how does the Code of Conduct Tribunal come in?
The Code of Conduct Tribunal is actually the most powerful institution of government that has been established to ensure compliance with the Code of Conduct Act. And there are 14 codes in that Code of Conduct Act, which is even enshrined in the Constitution of the Federal Republic of Nigeria, 1999, as altered, particularly in the 5th schedule of that Constitution. Now, number one rule in that Code of Conduct Act is conflict of interest. Now, I just wonder how the CBN governor will be able to establish before any court, howsoever described, be it Code of Conduct Tribunal or not, that his interest, that is his interest in becoming either a governor or a president, whatever, is not going to conflict with his regulatory authority in respect of the financial institutions owned by his opponents. I mean, there is no way you can perfectly convince any court in respect of that. Now, the Code of Conduct Tribunal will operate if a recommendation is made to it by the Code of Conduct Bureau. And the Code of Conduct Bureau has a duty to investigate the CBN governor or any public officer whatsoever described, including the President of the Federal Republic of Nigeria, to see whether certain actions that he has done or refused to do or has neglected to do in the past or now will be such that it will conflict with the constitutional or the statutory duties imposed upon him by law. In this instance, regulation is a duty imposed upon the CBN governor. And regulation must be either for those people he likes or those people he does not like. In fact, there is no way you can be in a political party and you will not be able to rule a line between those who are for you and those that are against you. The CBN Act is clear, and it makes the CBN governor, he or she, to be an impartial arbiter who must have no preferred candidate amongst the people that will regulate or the institutions of the banking sector that he must regulate, or even the monetary policies that he must bring out. In this instance, it is a shame that the CBN governor will not be able to defend himself in this area.
Let me bring back Chime Kingsley. He joins us now via phone. Kingsley, again, apologies for that glitch in the connection. But the good thing is that you're here and you are with us. And so we need to talk about, I think it's one of those days. We need to really blame this on the technology. I lost Kingsley's connection again, so I'm still with Dr. Ogunyemi. I'm trying to, get my fingers on some of those things you've highlighted now. Looking at that action that some Nigerians like yourself would expect from the Code of Conduct Tribunal, let's also look at the definition of, public service, going by Section 318 of the 1999 Constitution, which you also mentioned. But I want us to go through that again, which is what the CBN governor, it is also that which the CBN governor has also invoked by asking the court, does he have an argument, on the basis of what we've seen in Section 318 of Nigeria's 1999 Constitution?
Yes, the CBN governor may have an argument in the area of freedom of association, which is guaranteed by Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999 as ordered, with respect to his fundamental rights to freedom of association, to freedom of political participation, to freedom of inclusion, and issues that has to do with freedom of choice. Yes, he may have that kind of argument, but the issue now is who is making that argument. The specific issues that has to do with with his fundamental rights under the Constitution of the Federal Republic of Nigeria, it is not absolute. It is not absolute. In fact, it is actually moderated by the CBN Act and moderated by those conditions included in the Constitution that are the exceptions to the issues dealing with fundamental rights, including fundamental rights to life. The right to life is not absolute. If you commit an offense, you commit a crime, and that crime is such that it takes away the life of another, a court may sentence you to death. You cannot be hard to complain that, after all, your right to life is guaranteed by the Constitution, and no court can sentence you to death. In fact, in military service, there are courts in the military service that you sign out your right to proceed against the government if you lose your life in the course of training as a military officer. And the Constitution provides that should not be seen as a derogation from the fundamental rights to life. In the Constitution of the Federal Republic of Nigeria, Chapter 4. So the CBN governor in this instance cannot be hard to complain that his fundamental rights to freedom of association has been restrained by the Electoral Act, particularly Section 84, Section 12, because it is not. He is a special person, as an unelected but appointed political officer, technical officer in charge of the CBN, he's a technical officer in charge of the CBN. He is supposed to stand clear, in fact, almost aloof from political interventions or political partisanship.
I bring Kingsley here. Kingsley, quickly here, Kingsley, let's try to make sense of the constitutionality of what we're dealing with at the moment. That's one word sometimes I try to run away from, so I don't stutter on that. But again, talking about some of the key things, looking at the CBN Act and the 1999 Constitution, the CBN Governor has asked the court to look at what is happening at the moment, citing Section 318 of the 1999 Constitution. Does that hold any water for you as a legal practitioner?
Thank you so much, and I apologize for the technical issues I experienced just the afternoon. I think the issue of constitutionality and otherwise, Section 318, is subject of litigation. So I was decided to into delving into the substance of the case. However, it is a controversial fact that Section 318 of the Constitution never said that a central bank governor or the attorney general of the state nation or the appointee of the political executive falls under the item mentioned under Section 318. What that was not mentioned, it is excluded. As old as 2010, the Court of Appeal has asked us to say that the Attorney General of the state nation is not an employee of a civil staff under Section 318 of the Constitution. Unfortunately, in the case of Oni and Privacy in 2019, the court also held that position that ministers who are policies of government are not employees because these people are not paid, their terms and conditions are not explicitly stated. They occupy those positions at the whims and caprices of their appointors. So, this was that thinking about when I learned that they called a federal high court in Romania and stopped that Section 844 of the new Electoral Act on the ground that it contravenes the provisions of the Constitution. While that remains the position of the lower court as it is today, I believe that because of our appeal, I believe the Supreme Court will not waste time studying that position. So, going by laid out provisions of the Constitution, and for the fact that both the CBN Governor, the Attorney General of the Federation, the ministers, and the commissioners, and all the policies of all the steps of government were not contemplated under Section 118. It clearly stated those who are affected. So, my position is this. Those who refuse to abide by the provisions of Section of the Electoral Act will respect to the resignation of those appointees from the election. We face the consequences at the end of the day. That's my position.
Well, Chime, thanks. And, I was able to get some of your points. I think we still have a bad audio connection, and I'm hoping my producers will be able to work on that. So I come back to you, Dr. Ogunyemi. Looking at, commentaries by Nigerians, they're divided on this, and we're not ready to put that on the scale yet. But the thing here is that you're already looking at, for some, they're looking at the clarity of the law, and that it is out there and clear. Perhaps they think that the central bank chief is trying to test the waters and perhaps also give to the country another judicial precedent. But quickly here, the fear of some, especially politicians and non-politicians alike, they're looking at INEC's sensitive materials. I don't know if you've seen that argument, which in Nigeria is kept in the central bank. They think that that is now, misplaced if we have the CBN chief also eyeing, the medal.
Of course, that's a plausible argument. with respect to touching on the neutrality, if you like, impartiality of the CBN handlers. Any smart aleck can go to court to argue that he lost an election in which the CBN governor or any CBN officer is involved because he suspected or he suspects that they had tampered with the sensitive materials in their votes. I mean, any smart lawyer would do that. That is truth. Actually, I actually wonder why the sensitive materials are kept in those votes anyway. But if you even discount that, the truth of the matter is that the CBN governor, who is he supposed to be by the CBN Act, should be one, an apolitical person, two, a person who is honest or considered to be so accountable as to be trustworthy, and three, a person who is immune not only from partisanship, but also from the issues that has to do with nepotism. He should not be a nepotistic person. And finally, he should be a person who is fair and is intelligent enough to be able to understand that every move, including even ordinary sneezing, could affect the market, could affect the monetary value, and could affect the whole economy of the country. Just ordinary speculation that the CBN governor of a country, that the governor of the central bank of a country is intending to participate in politics is enough to make the value of the currency of that country to begin to spiral down south, because it actually means that the governor of that bank is losing some kind of interest in the economy and going political. I mean, it is like that. We may say these are sentimental arguments, but we will leave the courts to interpret in under our jurisdiction, our jurisprudence, whether a CBN governor that has been deliberately immunized from partisanship, such that his office and the institution of the CBN is detached, almost completely detached from the Ministry of Finance. Do you know this Ministry of Finance does not supervise the CBN? That is the intendment of the lawmakers, to make the CBN so independent that even the Minister of Finance does not control the CBN governor. It does not, it cannot, because the law has created the CBN as a complete institution that is absolutely free from political interference of the Federal Ministry of Finance. That is it. So if the head of that bank now decides to go into the murky waters of politics and says he wants to be in partisanship and is contesting whatever position, maybe Senate, the president, the governor of his state, whatever, that person has actually lost the vote of confidence of the financial sector and the players and stakeholders in that sector.
Well, we'll take a moment. When we'll come back, we'll stretch it further and also look at some of the appointees of government that we've also seen, jumping into the fray and has anyone resigned yet. That's when we return. Stay with us. Well, if you just joined us, you're welcome. It's VSA here on News Center Television, and of course, it's a home stretch. And we're talking politics in Nigeria, specifically as the country journeys towards the 2023 elections. Keep in mind, here in May 2018, the former deputy governor of the Central Bank of Nigeria, Adebayo Adelabu, resigned from office to vie for the governorship seat of the APC in Oyo State. The rules of engagement of public service were clear. And what did he do? He left office. Nigerians have asked Emefiele to do the same, resign if he wants to vie for office, or be sacked. Now, we should also recall that the Attorney General of the Federation secured a judgment in the Abia State High Court asking political appointees to be allowed to vie for office, contrary to Section 8412 of the Electoral Act. Now, the argument is that this section of the Electoral Act negates Section 40 of the Constitution, which states that every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political party, trade union, or any other association for the protection of his interests. Still with me here is Dr. Tunji Ogunyemi and Chime Kingsley. Gentlemen, thanks for your time. Let's start with you, Chime Kingsley. The issues here, legal minds like yourself will like to jump and make sense of the role of the National Industrial Court in this issue.
Thank you so much for having me back. First, let me make a clarification with respect to the constitutionality and otherwise of Section 8412 of the Electoral Act 2022, which has just a lot of controversy, which completed to a legal dispute where the judgment was delivered at the Federal High Court of Nigeria. While I would not want to speak on the pending matters in court, I want to make it clear that Section 8412 of the Electoral Act is not inconsistent with the provisions of the Constitution. Section 40 of the Constitution is not absolute. Indeed, no provision of the law is absolute. There must be an exception to every provision of the law. The provision of Section 318 of the Constitution is also clear as to who a public servant is or contemplated under the law. And CBN Governor, the CBN Governor, the Attorney General of the Federation, the Minister, and all the appointees of government are mentioned under those categories of persons mentioned under Section 318. So there's really no dispute, as far as I'm concerned, whether a national industrial court or Federal High Court, as it is presently constituted. The question of employment of the Governor of Central Bank of Nigeria or termination as emolument, benefit, as case may be, has never been in doubt. That whether National Industrial Court to intervene in situations such as this. It is indeed a constitutional question which our Court of Appeal and the Supreme Court will have to make a pronouncement one way or the other to rest this matter once and for all. So as far as I'm concerned, and as far back as 2010, the Court of Appeal has made it clear in the case of Adamu and Takori that those who were not mentioned in Section 318 of the Constitution were not contemplated, specifically the Attorney General of the Federation. And more recently, in the case of Oni versus Fayemi in 2019, the court also had the same position, that a minister who is an appointee of a government is not a public servant contemplated under Section 318. So what does that tell you? It tells you that the provisions of Section 8412 of the Electoral Act is constitutional. As far as I'm concerned, this is without prejudice to the judgment of the Federal High Court in Oman. So I'm not saying the National Industrial Court has a role to play or may be invited to make an interpretation on the provisions of the Constitution. The question of whether the Governor of Central Bank is an employee of the government has never been disputed. It is about his constitutional right or the constitutionality of him contesting an election without complying with the provisions of the Electoral Act. You can belong to an association, it's not an issue. You can participate in whatever the association is doing. But for the purposes of being contesting an election or being nominated, you must abide by the provisions of the Electoral Act, which regulates electoral activities in Nigeria. You cannot pick and choose which legislation suits you.
Okay, quickly, let me jump in here, Chime. I'm staying with you before we go to Dr. Ogunyemi. Still with you, Chime. Listening to you, since as a citizen you can't cherry pick which section of the Constitution to go with, Godwin Emefiele has openly stated to be a member of the APC. And looking at that section 40, does this qualify as, partisanship or just a member or an association belonging to a political party? Help us here. When they say he's a member of the APC, isn't this about section 40 of the Constitution of Nigeria?
Yes, I must have to make this point.
Yeah.
That our laws are not interpreted in isolation. If we interpret a provision of the law in line with the circumstances of a given situation, Emefiele granted has the right to belong to the political party of his child, provided under section 40. He has exercised that right. He can do every other thing a member of that political party can do. But for the purpose of contesting in an election, he is not be susceptible to the provisions of the Electoral Act, especially when that provision is not in contradiction with the provisions of the Constitution. That is my point. He has the constitutional right to exercise it, but if you must participate in an election, you must play by the rules. It's like someone saying Constitution guarantees that have to belong to a political party. You must have to fill the form, get a membership card, and abide by the articles of association or the Constitution. You cannot check it and say, the Constitution guarantees that you must belong to association. You must abide by the rules and regulations guiding such association. And in this case, the Electoral Act empowers the INEC and indeed the Constitution. Now, for you to participate in an election, you must abide by the provisions of Section 840 and 8412 of the Constitution. I only hope and expect that in the coming days, the Court of Appeal and even the Supreme Court will let you rest, because that decision at Ogunyemi High Court, with due respect, doesn't seem to represent the position of the law. The section which the court relied on in saying that it offends the provision of the Constitution was not in conflict with the Constitution. That is my position on this issue.
So one last one here before we come to Dr. Ogunyemi, and it has to also do with the Section 84, which you also try to highlight. Let's talk more about it. Section 8412 of the 2022 Electoral Act. It is one of one that is also causing ripples amongst Nigerians. Speak to us about that section of the Electoral Act, 8412.
Yes, sorry, I didn't get the question. What is your question, please?
We wanted you to comment on Section 8412 of Nigeria's Electoral Act, which is one that is causing a big debate in Nigeria political space, as the governor of the CBN has said he is interested in running for office.
Yes, I have said it before, that for me, Section 8412 of the Electoral Act is constitutional. It is not in contradiction with any provisions of the 1999 Constitution as amended. And as the CBN Governor, if he must participate or vie for election, he must abide by that provision. However, I am not oblivious of the extant judgment of the Federal High Court, which has struck down that provisions of the law.
Should we weigh in Section 12(2)(a) of the CBN Act of 2007 here, which states that the CBN governor shall cease to hold office if he is not capable of carrying out his duties. With what is playing out now, does this qualify as incapability to carrying out his duties?
Of course, it has both political implications and social implications. It depends on the type of device it belongs to. Of course, it will tell you that our monetary policy and all the statutory provisions that powers the CBN to act, that they have not so far or found one in any of them. So, of course, those who are supportive of it would argue that it's capable, that his intention to vie for any position in Nigeria has not affected the workings of the CBN. But if you're on the other side, you begin to see from a different perspective. Let us not forget that Central Bank houses some sensitive materials which INEC uses in conducting elections. So if someone who's a custodian of these sensitive materials is allowed to participate in the same election, there is likelihood of compromise. That is the question about whether there is a compromise or not. But the likelihood that is going to be compromised, the economy is going to suffer, and there will not be transparency. So that is the what I'm looking at. So whichever way you belong, you have a position to take. But generally, it is unthinkable. It is unfortunate. And I never expected that they would come when a central bank governor will indicate interest to enter into the murky waters of politics while retaining his position as the governor of central bank.
Okay, we'll come back to you. Let's bring in Dr. Ogunyemi. Dr. Ogunyemi, thanks for your time and patience. We've seen quite a number of ministers expressing their interest, and they didn't stop there. They have also gone further to pay and collect the presidential nomination form. So looking at Section 8412, that expressly stated that political appointees have to resign before vying for offices. What's the state of that section of the Electoral Act? How do you feel as a citizen of Nigeria saying not one, not two, political appointees in this administration already picked up forms and nothing has been activated in tandem with this particular act?
What Section 84, subsection 12 of the newly amended Electoral Act 2010 provides is that apart from the fact that civil servants are expected to resign their appointment in the light of any contest for election, 30 days to the day of that election, this Section 84, subsection 12 requires any political appointee, and by political appointee is defined in that act in terms of ministers, etc., must resign their appointments even before party primaries. That's the cross of the matter. Before party primaries. And I think they put about 60 days before that time. So if we do have, and don't forget that whereas the High Court in Maya might have struck down the provisions of Section 84 of Section 12 and require the Attorney General to delete it from the new law, do not forget that the Court of Appeal, which is the correct law, has actually ordered that there should be a stay of execution of that order of the High Court, which means the law we have now is that Section 84 of Section 12 requires all political appointees to resign. The issue is they must resign by the provision of that law even before the primaries of their political party. And election in Nigeria is defined not only as the general election alone, but it actually begins from party primaries. So if you are not part of party primaries, you can no longer be heard that because you were part of the election, you should be recognized. No, you must participate in party primaries. So the novel thing that this particular section of the new law has brought in is that it has excluded any person who is a political appointee who fails to resign his appointment before the primaries of the selection of his political party and also exclude them from even voting during that primary. That's the issue. So
listening, sorry to jump in here again. So listening to you, if these political parties, specifically the ruling party, has come up to say its primaries will hold this month of May, that is clear, clearly, out of the 30-day mark. It then means that some of these people that are yet to resign have actually breached that section. Is that what it is?
Exactly. They have done themselves incalculable damage by not obeying the law. And don't forget, the decision in Umuahia by the High Court is no longer the subsisting law. The law now is that Section 84 of Section 12 subsists. Not only that, they cannot participate in electing or be elected in a party primary. It's not only that they cannot just contest. They must not participate in electing or being elected in their party primaries, except they resign. And the window, the period given to them to resign before party primary has actually expired, because all political primaries must be concluded by the first week of June. And today is the 11th, I think. So any minister who has not resigned as on the 3rd of this month has actually shot himself in the foot.
Well, that's amazing. And what readily comes to mind is what happened in Zamfara. And some are saying, I hope the APC has learned some lessons here. But quickly, let me bring in Chime before we wrap up. I want both of you to also talk about the role of INEC here. But Chime, Kingsley, good to know you're still there. Help us make sense of some of the things already highlighted by Ogunyemi. You're the lawyer here. These ministers and political appointees, especially in the ruling party, not one has resigned yet. What does this portend for the party?
But I think even the party members know the consequences of their action. The consequences are enormous. And the implication is that at the end of the day, whoever that came out of this time that was blocked by not abiding by the provisions of the Electoral Act, we go to a nullity. Section 8 for 13 is based on the consequences of political parties or individuals who refuse to step down to disrupt the elections. So the consequences are great. But let me just go quickly out. The first speaker had mentioned that based on the first appeal order, that petition of the matter should not be that the by implication section 8.4 remains expert. I do not think that represents the position of the law. The order of that court remains valid and subsisting until the time on appeal by the Court of Competent Jurisdiction. So while I am also optimistic that judgment based on the appeal, but at the big day, that judgment of that court remains expert to the extent of the judgment. So the consequences of political parties not abiding by the provisions of the Constitution and indeed the Electoral Act cannot be imagined. I think they are just hopeful that at the end of the day, the Court of Appeal will help the position of the Court of Mark. But that is a dangerous game play. And I hope that in particular, and the two main contenders political parties know the consequences of the act. I do not stipulate for that.
And what's the role of INEC here, Chime, and the judiciary, especially as it may hurt the parties if such officials emerge, as you already highlighted?
Yes, let me speak on the position of the judiciary in particular, because the judiciary plays a very sensitive role in the electoral process and democracy. A judgment of a court has a far implication on individuals, citizens, and society at large. So I think that judges should be circumspect and be careful, particularly as it relates with political cases. Because more often than not, some of these judgments and decisions start emanating during electoral campaign. So it appears that every political party has their preferred course where they obtain favorable judgment to continue to, engage in illegality. It's unfortunate, and I think the point has been made, particularly on those who are desperate about power, and because of that, they are undermining our judicial process. Those who have benefited from the benevolence of judiciary must resist the temptation of the vacillating judiciary.
All right, okay, and back to you, our closing moments. Let's see if we can actually take this home. The electoral umpire, Dr. Ogunyemi, is here in all of this. And sometimes they say they're waiting in the wings, waiting, even though they're also going to be a part of the primaries of these political parties. What's the role of INEC? Can they bounce in now or jump in now, or they wait till, when you're done and dusted, and they just come and hit it and say, well, you didn't do well, so you go back in line?
The laws are clear, very clear. Political parties are in charge of their internal affairs. And INEC, except where there is a clear breach of the act, will not descend into the arena. So it behoves a political party to do the needful, to do what is right, what is legal. Otherwise, it will suffer the unintended consequences when an adverse claim is brought before it after the election.
I wouldn't let us come here and have this conversation without asking you a personal, opinion on ASU's strike. If we can do this in a minute, because the strike has just been extended. Help us make sense of this. How is this business going? Because some have said if political parties would put 100 million naira on a sheet of paper, how is it that it's so difficult for the government to get ASU what is needed to run our universities? Dr. Ogunyemi.
It comes to the issue of seriousness. Sulaiman, if the government is serious about education, particularly in respect of the directive principles and objectives of state policy that is contained in Chapter 2 of the Constitution of the Republic of Nigeria, then government will not be foot-dragging with respect to an agreement signed freely in 2009. Imagine a 2009 agreement, 13 years thereafter, the government has not done anything about it. And what is the agreement? Very simple. It's about revitalizing the university system and, of course, the tertiary system, for which money has been provided through the TET fund, that is the Tertiary Education Trust Fund, but which government has deliberately refused to release to the university system.
Dr. Ogunyemi, I'd like to thank you for your time. Chime, Kingsley, many thanks. Irrespective of that glitch or those glitches, you were able to also make it. To Africa, thanks for watching. We'll be back again. If you missed out on this, you can catch up on our YouTube channel. I'll be back again. I'm Sulaiman. See you then.